Welcome to Criminal Law Unfiltered.
Welcome back to Criminal Law Unfiltered with Robert M. Helfend. Robert is the founder of the Helfend Law Group and has spent more than 4 decades defending people charged with serious state and federal crimes across California. In that time, he's seen how the first decisions made after an accusation can shape everything that follows, often long before a case ever reaches the courtroom. I'm Evan Mack, and today we're focusing on the first 48 hours after a serious felony accusation and why that early window matters so much. Robert, sir, welcome back.
Thank you for having me.
Listen, Robert, why are the first 48 hours after a serious felony accusation often the most critical part of the case?
Well, I don't know that that is actually true. I wouldn't say like the first 48 hours or so critical. What is critical is that you do not make any statements to the police, period, ever. Okay, so you need to hire counsel so that you get the police off your back so they know that you're represented. I call them and I say, I'm representing, Mr. or Mrs. Smith, and don't talk to them. Okay, we're not giving you a statement, because typically what police will do is they will try to lull you in. And they're one of their lines, which, listen, we got this accusation about you, and we need to know what's your side of the story. I mean, we've only heard one side, so now's your chance, and you're only going to get this one chance. So why don't you tell us what is your side of the story? And that is just no. I'm not saying anything, because the reason why you don't say anything is because once they have a story, then they now will use that. They have all this time to prove why your story is not right. And you don't want them to have that. Okay? You don't want them to have that until you're on the stand and you make them prove that what you're saying is not true. That is the reason why you do not talk to the cops, because they're not your friends. They have a job. That's their job. Their job is to support the victim and get a conviction for this victim. So you do not say anything. Another thing is, in any kind of crime, especially like some sort of a sexual assault or something like that, if you say, what are you talking about? It was consensual. Well, that was a piece of information that you gave them you thought was so innocent, is now you over. Excuse my French, because I don't know if is French word though. But I'm just saying, you've just screwed yourself, because now when you say it was consensual, you put yourself at the scene.
Yeah.
So, I mean, you don't say anything. My name, my date of birth. Yes, that's me. Okay, tell us about it. I don't know. I have a lawyer. Here's his card. Here's his number. Call him. He'll speak for me. That's it. So, I mean, as far as the 48 hours, there's nothing to say.
Yeah.
There's nothing for you to do. I mean, it really depends on the circumstances. If police are looking for you, it's best to turn yourself in, because if you don't turn yourself in, then at a trial, they'll tell a jury, oh, you see, he ran. That's a consciousness of guilt. So, it all depends on the circumstances, but the first 48 hours is just some TV show. The first 48 hours means more to the prosecution or the police than it does to me. Just don't talk. That's it, period.
So with that being said, though, how can statements, actions, or even that silence during those times affect what prosecutors do next?
These things don't unravel that quickly. Okay, the prosecutor doesn't have the case in the first 48 hours normally. Sometimes, at a homicide crime scene, sometimes a prosecutor is on call and they'll come out there. I haven't seen that in a long time. Like we were just speaking off camera before we went on today about this homicide. that I just finished that trial. There was no prosecutor out there. So you got to understand something. These, like on a murder case, police will take you into custody whenever they find you or see you. You're going into custody, but their investigation is not complete. It takes, some time for them to complete that. And then once it's complete, they give it to the DA, and then the DA gives it to the defense. So that's just the way it works. In federal cases, the prosecutors are working with the FBI or the DEA or Homeland Security or ATF while they're doing the investigation. So that's a whole other, can of worms we could talk about. But as far as the first 48 hours, it's just, like I say, it's a TV show. It's more important for them, not for us. We don't talk. I like to get involved, find out what's going on from the prosecution, but that's just the way it is. If my client's in custody on a homicide, and they don't bail out, which bail in at least around here is normally $2 million on one count of homicide. I won't get to discovery until the guy enters a plea of not guilty, or we just continue the arraignment.
So Robert, what about like early decisions? How do they kind of influence what evidence ends up being used or maybe even challenged down the road?
Like I've said before, the most important thing is don't talk to them. That's the most important early decision you can make. It's not like, first of all, are we talking about the first 48 hours, or are we just now talking about the early stages of a proceeding? That's, because the first 48 hours don't talk. But as you go through a case, we need to look through the evidence. And one of the things that could be important is once you see a statement from a witness, you get your investigator out there and you lock down, the witness's statement to your investigator. So, was this, did you say it like this? How was this interview conducted? Did you see this? Things like that. And maybe you can find some Ring doorbell cameras yourself or surveillance videos yourself. But as far as like early, it's difficult to say because it's a case by case basis. It just kind of depends. I would need, you'd have to tell me like a hypothetical, like what if, then what would you do more than, well, what is the things we should do in the early stages of this case? I don't know yet.
To piggyback off that, the kind of case that you just got finished with, what would you do there as far as that goes? As far as like, as far as giving you like a hypothetical.
The best thing to do in that case was they had a few, people that I knew they were going to call to the stand. And, we wanted to get our investigator out there to talk to them. Of course, a few of them didn't want to talk with us, but I got their statements, and their statements weren't that helpful because it was very consistent with what was said at trial. I just knew what I needed to do with the evidence that the prosecution had in order to show the truth, which in that case, the truth was hard to come by because the prosecution wasn't going with the truth. They were just going for the conviction, which is very difficult for me to say that's the way this works a lot of times. But that is the way it works. When you get to trial, it's supposed to be about the truth, and it's so many times not. It's about what the prosecution can prove, and there's a difference.
Yeah. So to close things out, though, Robert, you always say don't talk if you get in if you're getting arrested and things like that. But what advice can you give a person if maybe they've said something or maybe said too much before they kind of contact a person like what would you say to those people?
Well, first of all, you're not going to make any more statements. You're not going to go clarify that with the police. Okay, that's not going to happen. All I want to know from them is, how do I clarify this, what you said? Is there somebody else that we could use to clarify that statement if you're not going to put your client on the stand? But if you're going to put your client on the stand, you need to make your client aware of what they said. So what did you mean by this? And how are we going to clarify this? So typically in a murder case, where it's not a who done it, but a why done it, which is lots of my murder cases are why done it's, you basically have to put your client on the stand. Because if you don't put your client on the stand, then the judge is not going to instruct the jury. At the end of a trial, the judge instructs the jury on the law. And the judge is not going to give a self-defense instruction on the law of self-defense if your client doesn't get on the stand and say, I felt my life was in danger. I felt that I was just about to be injured so critically. I felt that I was either going to get great bodily injury inflicted on me or I was going to die. If you don't have the client say that, then you don't get it. So you have to put your client on the stand in like a murder case. And so it's important to lock down with your client. Why did you, this is, an issue here, what you said to the police. So what did you mean? And so you want to know what they're going to say.
Good stuff. Rob, thank you for the time, sir.
As usual. Thank you.
All right, guys, that's it for today's episode of Criminal Law Unfiltered. When you're facing a serious felony accusation, Robert kind of let us know that first 48 hours are somewhat of a myth, but early action can still determine how much room you have to defend yourself later. To learn more about Robert Helfend and the work he does at the Helfend Law Group, visit robertmhelfend.com. Thank you for listening, and don't forget to like, subscribe to the show, and leave a review if you found this episode helpful. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.